Ladies and gentlemen, welcome back to the IndieZoNe. My name is Kathy. Although the defense's expert witnesses have largely been under seal, the defense did disclose the name of one expert that it intends to call to provide expert testimony at the upcoming April 9th motions in limine oral argument before Judge Stephen J. Hippler. And this name was disclosed in motion in limine number 9 regarding excluding Amazon click activity evidence at trial. If you go to the conclusion section of this motion, you will see, and this is on page 7, for the reasons addressed above, Mr. Kohberger respectfully requests that the court grant his motion in limine, exclude any Amazon and Amazon click activity evidence because it is improperly isolated, out of context, and does not take into account advertising influence and omni-channel features. Mr. Kohberger intends to offer expert testimony of David Howe at the motions hearing on April 9th, 2025. What is a motion in limine? This is basically where the parties are coming to Judge Stephen J. Hippler and asking for an order pre-trial before the trial even starts regarding the admissibility or unadmissibility of evidence. And here we see in this motion in limine number 9, the defense is seeking the exclusion of Amazon click activity evidence at trial. Let's take a look and see what this document says with more specificity. If you go to page 1, you will see that Mr. Kohberger is seeking the entry of a court order in limine, that's before trial, excluding any Amazon evidence, any of his purchase activity, and, quote, Amazon click activity evidence by Mr. Kohberger. It then says at the bottom of page number 1 going into page number 2, more specifically, the defense asserts that with the limited disclosures made by the state, the lack of raw data, lack of complete data, lack of disclosure of expert opinion, lack of explanation of, quote, Amazon click activity, end quote, or any analysis related thereto amounts to cherry-picked, limited data that does not show a full picture compared to warrants that requested excessive data. The state's refining of all of the Amazon activity history and Amazon click activity is out of context, it's incomplete, it's unfairly prejudicial, thus making it inadmissible. This is the defense's theory here. The defense then says that incomplete, irrelevant, and unfairly prejudicial evidence is barred by rules, and these are rules of evidence in Idaho. 106, 401, 402, 403, 702, and 703 of the Idaho Rules of Evidence, and pursuant to the 6th, 8th, and 14th Amendments to the United States Constitution and Sections 13 of Article 1 of the Constitution of the State of Idaho. So here we see Mr. Kohberger raising legal authority under the Idaho various rules of evidence cited here, and also constitutional provisions of the state and federal constitutions. Mr. Kohberger then says that this motion should be read in conjunction with motion in limine number 2, excluding expert Shannon Cox. This is a state of Idaho expert witness who's been disclosed, and any other expert the state intends to use regarding all Amazon evidence. There's an introduction section, and it talks about the state's disclosure of Shane Cox as an expert who will testify about Mr. Kohberger's Amazon account, activity on that account, and to include logins and click activity. The state wants to use very specific, narrow dates here. According to the defense, the state has not defined what Amazon click activity is in any reports or expert disclosures. nor provided any opinions or analysis related to the limited data it has produced. So this is where the defense is going into the prejudicial and the cherry-picked, if you will, nature of this evidence. Next, on page number 3, it says here, in this ever-evolving age of technology, that Amazon, according to the defense, uses artificial intelligence to improve the customer experience by helping customers find products that matches their interest and their preferences. Amazon's artificial intelligence-driven system does not just reflect searches, it actively shapes user behavior through recommendation. Going ahead to page number 4, in this case, the state's refining or limiting the Amazon click activity to a specific click or a specific item, excludes data, takes things out of context, and could tell a completely inaccurate story to cause the jury to speculate about intent. And when it says here intent, this would be Mr. Kohberger's alleged intent. Full Amazon advertising logs and recommendation data must be reviewed to determine whether a purchase was truly user-initiated or heavily influenced by Amazon's artificial intelligence. So what the defense is arguing here is that these clicks may not have even been the intention of Mr. Kohberger, but it was heavily influenced by AI recommendations. Then, we go into the next section, which is argument, which begins at page number 6. It says here that Mr. Kohberger believes that the state intends to use Amazon evidence to prove elements of its case. To allow such in the face of the explanation above and the failure to disclose, this would be expert disclosures, pursuant to Judge Stephen J. Hippler's October 9th, 2024 order. There were some dates that were set out, deadlines to provide expert witness disclosures from one side to the other, and also Judge Hippler included what needed to be contained in those expert disclosures, including a curriculum vitae of the proposed experts given his or her skills, knowledge, and experience that would help determine why this person was being offered as an expert witness, and if they had the SKE, skills, knowledge, and experience to proffer such testimony, whether it was relevant, and also a synopsis of what the opinion testimony at trial would be. These were the things that Judge Hippler's order required the parties to disclose. The defense then goes into further detail here regarding Rule 106, that is the Idaho Rule of Evidence, guards against the introduction of incomplete evidence, so that provides legal authority for Judge Hippler, according to the defense, to throw out this evidence, to exclude it from trial. In fairness, according to the defense at page 6, incomplete Amazon data and click activity should not be offered as evidence. Cherry-picking specific clicks or rules or purchases out of an Amazon click history removes all of the context explained above, and Idaho Rule of Evidence identifies the confines of the completeness doctrine when it comes to evidence. And then the defense quotes, if a party introduces all or part of a writing or a recorded statement, an adverse party may require the introduction at that time of any other part or any other writing or recorded statement that in fairness ought to be considered at the same time, inciting to this rule of evidence. Then the defense states, under the common law rule that underpins Idaho Rule of Evidence 106, the reason for the completeness doctrine is that there is a danger that an out-of-context statement may create such prejudice that it is impossible to repair by a subsequent presentation of additional material, citing to State versus Ogden, which is an Idaho Supreme Court case, and then quoting from a U.S. Supreme Court case Beach Aircraft Corp. Versus Rainey. Then going into, for further support, rules 401, 402, and 403 at the bottom of page 6 to exclude evidence that is irrelevant and unfairly prejudicial. The defense then argues that evidence must be relevant to be admissible, and citing to Idaho Rule 402. And also State versus Sheldon, which is an Idaho Supreme Court case, and then explaining what these rules and other rules of evidence require. And then going into the conclusion, this is where the defense concludes, for these reasons, Mr. Kohberger requests that this court grant this motion in limine to exclude any Amazon and click activity. And then this is where the defense argues and points out that Mr. Kohberger intends to offer expert testimony of Mr. Howe at the motion hearing, which is forthcoming on April 9th, 2025. They're actually scheduled to occur by entry of Judge Hippler's order of January 31st to start on the 9th of April, and if necessary, continue into the 10th. A large number of motions in limine that have been filed by both sides, and given the complexity of some of them, and that there will be, we know for at least this one, for sure, live expert testimony, I highly recommend that you also plan to watch the hearings on the 10th, because the court has said in its order that the hearings will start on the 9th and if necessary continue on to the 10th. And given the sheer number of motions in limine and these sometimes complex legal and in some cases scientific theories that must be taken into consideration, it appears this will be a 2-day event. In any event, this is Kathy. If you have any comments, any questions, any feedback, please leave them here. And if you can, please like and subscribe to the channel. It does help us grow. Thank you for joining us here today.